Heyo and welcome. We are a bit on road's end. We are here for the sentencing of Henry Dinkins for the kidnapping and murder of Breasia Terrell. And you who have followed me covering this trial, you know that I have a lot of criticism towards the prosecution. You also know that I had criticism against the judge during the verdict, because I always want justice to be served via a good prosecution. And you might disagree with me on that, in this case, but for me, the very fact that the trial should have was scheduled to 5 weeks. Then it became a bench trial, and then it was cut down to 3 weeks. In the end, 14 days. That tells me that the prosecution believed themselves they had a weak case and were going for emotions towards the jury. And I would argue that a long time. But you also know that I do believe that Henry Dinkins did it. I saw buried in BS the evidence needed to convict him. But we can't always get what we want. We got a lousy prosecution and a judge who, in my opinion, opened up for some appellate issues. Now, do I believe the verdict will be overturned? No. That takes more than this to get it overturned, in my opinion. I just wished it was handled better. And oh, hello chat. I see Gigi is up. Gigi, all our prayers to you that you get well soon or get better, get some sleep and some rest. So we want you along the ride for a long, long time. Christine is here. Nanya Bitness is here. Kim, American Dreamer, Robil, and I saw Jason earlier, and Eris, Debbie. Thank you all for showing up. And first some YouTube stuff. And you all know what those are. Press that thumbs up. And if you're not subscribed, please do. Oh, hey Lucy, new subscriber from Law and Lumber. Welcome here. Is this my first stream since, or didn't I have one Monday? Let me check. Yeah, I had the Zachariah Anderson case earlier this week. So, welcome. I hope you enjoy it here and that you stay. Yeah, the YouTube stuff. Yeah, like, subscribe, and at least view my videos and give a thumbs up if you like it. And eventually give me a subscription. And eventually, this guy I want to support, become a member. It's $3 a month, and you get access to members only content, like the renovations on the farm itself, and stuff like that, and access to the Discord. All right, but we are here for the sentencing now. I thought it would be a long day of sentencing, and apparently it wasn't. I can only see how long the Law and C word stream was, so I assume that not many of the victim impact statements were in, and that Mr. Dinkins probably didn't talk for too long. But just to be safe, this case is horrific. Breasia Terrell, shot twice, probably saw her murderer in the face when he did it. Hi, Heather, a new subscriber from Runkle. Hey, good day. Yeah, so a bit of, if you haven't followed this trial, this will be a bit of a trigger warning, because the circumstances in this case is horrific. And what you might not know, if you're completely new to this, is that Mr. Dinkins is a career criminal. He's on the registry. He has violated almost every parole he ever had. He has violated the terms of his registry. He should not have been out at all. So for me, this is a failure of the justice system. If he, for example, he was sentenced to 5 years in prison in the fall of 2019. He was out on parole 3 months after 5 months. 3 months after that, Breasia Terrell disappeared, kidnapped, murdered. Had the justice system done its job to protect the society from people like Henry Dinkins, Breasia Terrell would have been alive today. That's, yeah. So, yeah. Okay, people are starting to show up. And, yeah. But we are here for the sentencing. But just to make sure everybody knows that this case is deeply disturbing. I don't know what will be said during the sentencing, but no, whatever is being said, it's not going to be enjoyable. I'll be here to guide you through it. Maybe I throw in a comment or two meanwhile. But yeah, just so you know, you have been warned. Dun, dun, dun. No, not that one. Not that one. That one. All right. We'll do it like this. All right, let's go. That's Henry Dinkins. Fast forward.
You may be seated.
Check, everybody. Let me know if you want to use the volume. Looks like Mr. Dinkins is prepared to speak on his behalf. I wonder what he will say. Okay, what's going to happen is that the state will go first. They always do, with the recommendation of sentencing. They might talk about Mr. Dinkins' priors and stuff like that. So again, things can get really, really nauseating.
We're here in the matter of State of Iowa versus Henry E. Dinkins, case number FECR 415636. Mr. Dinkins appears personally and is represented by his attorneys, Mr. Freeze and Mr. Waters. The state of Iowa today is represented by County Attorney Kelly Cunningham and Assistant County Attorney Liz O'Donnell. Before we proceed with the sentencing, there is a matter I'd like to address on a couple matters. I want to commend everyone once again for how they've conducted themselves during the course of this trial. You've acted very professional and very respectful for the court proceedings, and I would ask that continue today. That's exactly what I expect. Second of all, as I was preparing for this sentencing today, the court noted that in my sentencing order that I did cite an indirect code section as it relates to count 1, and I'm going to correct that at this time. That code section will be 707.2(1)(a), and the order of the court will be amended to reflect the same. The court file reflects that on September 15th, 2023, this court found the defendant guilty under count 1 of murder in the first degree in violation of Iowa Code section 707.2(1)(a), and under count 2 of kidnapping first degree in violation of Iowa Code section 710.2. The court at that time did order that a pre-sentence investigation report be prepared, and this matter was continued until today's date and time for sentencing. Mr. Freeze, have you had the opportunity to review that pre-sentence investigation report yourself and also review that with your client?
Yes, Your Honor.
Are there any additions or corrections to be made?
No.
And Ms. Cunningham, have you had the same opportunity?
Yes, Your Honor.
And are there any additions or corrections?
No, Your Honor.
And Mr. Freeze, are there any motions at this time pending or any other reason why I should not proceed with sentencing at this time?
There are not, Your Honor.
Thank you.
Yeah, one little thing here. Mr. Dinkins wrote a letter to the judge before he was convicted. You can see that I will, let's see here. I will share that link with you here, because that tells me he already expected a conviction. But he took up a few things that were interesting. But since he is represented by lawyers, the court didn't even read it. But it could be a good little, it's a 1-hour stream that gives you some insight into the brain of Mr. Dinkins. Let's continue.
Ms. Cunningham, do you have anything to present in regards to sentencing in this matter on behalf of the state?
Yes, Your Honor. The state has a sentencing recommendation. In addition, there are a couple of issues that I'd like to address related to victim restitution. And then we also have Aisha Langford present, the mother of Breasia Terrell, who has a statement that she would like to make at the conclusion of this matter.
Thank you.
All right. Your Honor, relative to the court's finding of guilt on count 1 to the charge of murder in the first degree, the state recommends that Mr. Dinkins be committed to the Director of Adult Corrections for an indeterminate,
Seriously, lady, you wear zebra stripes to court? Somebody needs to tell her. I mean, I'm a big advocate for dress for court. I have seen ladies of the night wearing stuff like that. This is, ma'am, this is not an episode of Dallas. This is not 1988. Please dress for court. And she did this the entire trial, dressed like an episode of Dallas or Falcon Crest or whatever.
essentially life with no parole. And I recognize that this is a mandatory sentence, but I'm articulating this for the record. As to the charge of kidnapping in the first degree, again, the state recommends that he be committed for a period of life to the Director of Adult Corrections, recognizing that that is not an offense that is subject to parole. The question really that the state has had to consider is whether or not the state was going to recommend concurrent versus consecutive sentencing as to count 1 and count 2. The state certainly recognizes that these, are life sentences and that Mr. Dinkins is not subject to parole. But I think it's the facts and circumstances of this particular case that has weighed very heavily on the state's mind as to a recommendation of consecutive sentencing. So I'm going to walk the court through the state's thought processes and then with that being said, articulate where the state is landing on a recommendation of concurrent versus consecutive sentencing. In going back to Mr. Dinkins' criminal history, I would note that as far as adult offenses, we have offenses starting back in 1989. I think that's very important to articulate because the idea being when an individual commits a crime and they come into the criminal justice system, certainly the idea is that these individuals are afforded opportunities at probation. And once they've gone through that probation, ideally these.
Yeah, I saw the comment. She should rename herself to Patsy Stone. It's a British show called Absolutely Fabulous. And if you don't know how Patsy Stone looks like, that's her. Yeah, and even the same jacket. Oh, Jesus. Well, we deserve a little fun in all this misery. Let's continue.
Individuals, will understand the importance of being a contributing member to society and not to commit further crimes. That has not been the case for Mr. Dinkins. And unfortunately, when you look at his criminal history, starting back in December of 1989 with his first conviction for theft in the 4th degree and operating a motor vehicle without owner's consent, we have an individual who has been consistently involved in the criminal justice system up until the time of the commission of these offenses.
Yeah. I had a stream about his rap sheet here in Iowa. 98 entry in his rap sheet. 98. And that doesn't count in the neighboring states where he also has rap sheets. He could have been in jail for a very long time. But every time they cut him a deal or cut him a break, and now Breasia Terrell is dead because the justice system failed her. She should be alive.
For which he was convicted. So After those offenses, we've got his first conviction for sexual abuse in the second degree back in May of 1990. After he was sentenced to a term of prison, one of the things that the state noticed was that he had been released to work release in 93, having started his sentence in August of 1990, and he was paroled to the Work Release Center in September of 1993. Unfortunately, after he was paroled from the Work Release Center, we had the first revocation of that parole in 1994. That resulted in a completion of the violators program, where he again was paroled just a couple of months later to have his parole revoked then in January of 1995. And then he was once again released to the Work Release Center in January of 2000, having spent a significant period of time in prison at that point in time, whereas within a month he escaped from the facility.
Are you listening to this? Escaped, paroled, violated parole, back in prison, paroled again, ran away. And for you who don't know, his second degree SA was of a child. And he violated the terms of the registry his entire life, adult life. Over and over and over again. I agree, Peace Peony. How on earth was this man walking the streets? Because the justice system failed.
He was captured and returned and then finally discharged in May of 2000. Within the context of that sequence of events, I think it's important to note that in 1994, while he was on parole status, he in fact picked up a charge for possession with intent to deliver, which would be the Class C felony, and he was sentenced to 10 years prison for that particular offense. And I think that really speaks.
Yeah, he was sentenced to 10 years, but he served like 2 and then paroled again. He keeps reoffending over and over and over again. Reoffending. Doesn't care about his parole status. Doesn't care about the rules for the registry. He never cared, and the justice system let him not care.
To the issue of Mr. Dinkins and how he views himself relative to society, and rather than
No, that's a guy, Henry Dinkins, raped a child at age 17.
recognizing that as individuals who live in society, we each have an obligation to one another to respect one another's rights, but to recognize that there are boundaries and that we have an obligation to conduct ourselves in a law-abiding manner. And that's certainly something.
Oh, yeah, okay, now I know what you mean. Yeah. Breasia's mother probably didn't know about his essay, but she knew about everything else. Everybody knew in that area. Everybody knew who Henry Dinkins was. Everybody. And certain things in the trial was said that led me to believe that the mother of Breasia was not an angel herself.
That he has never learned, and he continued to engage in law violations. After his discharge from prison, I'm looking very simply at offenses that reflects a lack of regard for others. We have a violation of a no contact order in 2001. We've got a domestic battery resulting in bodily harm, and then a charge of endangering life and or health of a child in 2001. Then we've got
Yeah. Remember what he said a minute ago. He was sentenced to 10 years in 2000. Why is he out in 2001? Why? Why? And he keeps reoffending. 2001, he battered his then girlfriend, and I don't know what happened to the child. I haven't read the docket. But why was he out?
3 different offenses that occurred during the period of 2002 through 2003 involving thefts. We've got a violation for the sex offender registry starting in 2003. And then even after that, we have got 2 more violations of the sex offender registry within the 2003 and 2004 period of time. Moving on, one of the things that is certainly replete throughout his criminal history is you see that substance abuse is an issue that he has had ongoing problems with. There are a number of arrests and convictions for possessions of controlled substances and even OWI first offenses. And in several of those instances, he had been convicted of
No, it's either consecutive or not. For the murder and kidnapping. The murder is an obligatory life without parole. The kidnapping can be life.
WI third offenses 3 times. I bring that out because, again, this is yet another offense that places society at risk when you have an individual who is consuming any type of intoxicant, whether it be alcohol or drugs, and then is actively going out in the community and driving and putting any member of the public who is out on the street at risk. And then beyond just driving offenses related to his privileges to operate a vehicle that had been revoked, and that is an ongoing theme that we see throughout his criminal history. We do have a voluntary absence from custody. And we've got that type of history that took us up to the point in time where Breasia was kidnapped and then murdered in July of 2020. It's very sad. I mean, it's extremely sad. And you can.
We don't know. None of business. We don't know if he essayed that girl because she was found 8 or 9 months later. And the remains were more or less just skeleton. So we don't know. Is it a possibility? Yeah. But we simply don't know.
Consider those circumstances, but then we stop and consider the circumstances involving Mr. Dinkins, particularly as it relates to his relationship with Aisha Langford, his relationship with Breasia Terrell, and even the fact that his youngest son was the brother of Breasia. Mr. Dinkins took advantage of a situation that no mother could have conceived would have happened. You have a mother who is having that chance contact with him at a convenience store to have a discussion with Mr. Dinkins about the importance of spending time with his son and being a father. That's a conversation that any mother would have. And certainly a mother encouraging a father to spend time with his son is something that we see happening in a world where we want there to be those healthy relationships. you've got that scenario, and then we stop and consider the relationship of Breasia to Mr. Dinkins' son. As Aisha Langford talked about, the two children were very close to one another and essentially were attached at the hip. And so with Mr. Dinkins' son going to spend time with him, and the child wanting his sister to be there with him, a mother who's encouraging a father to spend time with his child and recognizing that in order to facilitate that, even though there hadn't been permission given for Breasia to go, but then finding out after the fact that when she's gotten off work, that very circumstance has arisen, and then for Mr. Dinkins to take that and remove Breasia from the apartment in the middle of the night. And then ultimately we find that that child's been brutally murdered, with her having been shot in the face on the side of the jaw, and having been shot twice in the front of her chest, and traveling to the back. The state can't even be.
That's not correct. She was shot once in the jaw and once in the chest. But yeah, I'm not surprised this prosecutor has no clue what the facts of the case is.
Begins to conceive what that 10-year-old child was thinking, as she was standing there and Mr. Dinkins presented that gun and fired and killed that child. And then you take that and you stop and consider that this family is forced to live a nightmare that they could have never conceived of. And it's not a nightmare that comes to an end. Miss Langford, her son, her youngest son, her oldest son, they're going to live with the repercussions of this for the rest of their life. Quite honestly, when you stop and consider Mr. Dinkins' son, he was an 8-year-old child. And how do you take a child of 8 who is at a stage in their life where children are innocent, and then that child is taken by his father after Breasia has been shot and killed, and essentially been a companion with him and forced to go with his father as his father took steps to cover up his crime. And it's changed that child. The youngest boy, he's had struggles ever since. The child's completely derailed, Your Honor, and he's acting out. One of the things that I've had discussions with the child about, and certainly this is something that Miss Langford has pursued, is the issue of getting the child into counseling. But the problem is the child's fighting that because the child doesn't want to talk about the issue. He doesn't want to talk about the issue because it hurts too much. And so now we have an 11-year-old who has no concept of the value of talking out and through something that's so painful, and he's living with that pain. And what it's doing is it's created a scenario where this child is not healing. Instead, he is angry and he's fighting the world. And you have a mother who has lost her daughter who has been brutally murdered. And now the mother, not only in dealing with the stress of that, now is in the position that she's fighting for the life of her youngest child, worrying about where that child's going to end up because he can't resolve the trauma that he's gone through. And I think, in considering all of those variables, while they are life sentences without parole, I think that this is a situation where the state is going to recommend consecutive sentencing because the dynamics and what has happened deserves consecutive sentencing. And so that's going to be the state's recommendation. Beyond that, Your Honor, I would note that pursuant to the provisions of Iowa Code Section 910.3 capital B, Mr. Dinkins is required to pay $150,000 in victim restitution to the heirs of Breasia Terrell. Aisha Langford, being her mother,
Well, that sounds good. $150,000 in restitution. Here's the deal. Mr. Dinkins has nothing. Maybe they can sell his cars. That will bring in a couple of grand, but everything else must be taken from his prison salary. So, no, the mother will probably never receive $150,000.
would obviously be one of those heirs. Breasia's father is deceased. And so I think under the rules of intestate succession, Aisha Langford would be the heir pursuant to what we would consider under our probate law. So I would identify that for the record. Additionally, Your Honor, there had been a claim submitted by Ms. Langford to the Crime Victim Assistance Program for loss of wages and then also for crime-related travel expenses. The Crime Victim Assistance Program did in fact pay out a claim of $6,055.25. So the state is asking for the payment of that restitution by Mr. Dinkins to the Crime Victim Assistance Program. As far as burial expenses, we don't know what that figure is yet. At the time of this trial, well, actually at the time that the state was preparing for trial, and I had been meeting with the pathologist to prepare her for her testimony. We had discussions. Breasia's little body is still in the custody of the Iowa State Medical Examiner's Office. And so as a part of that discussion, I indicated that once the sentencing was done, I would then contact the State Medical Examiner's Office and ask for the release of the body. Once we finish this particular proceeding, I will make that call, and then that will afford the family the opportunity to finally put Breasia to rest. So there will be an additional motion filed by the state setting that matter for a victim restitution hearing, as we will be seeking those burial expenses. Beyond that, Your Honor, one other issue that I need to talk about. There has been a change in procedure relative to the payment of travel time and even payment of time for victims who have come and testified in trial. It used to be that where a witness was called to testify, we could turn in the subpoena, we could identify if they were there for a half day or a day, and then put mileage on the subpoena. We've been advised by the clerk's office with the changes that have occurred. First of all, the court has to make a determination that Mr. Dinkins is indigent. I know that defense counsel has filed various motions identifying Mr. Dinkins as being indigent. And if the court does make that finding that he is indigent, then the state has a claim for payment of non-expert witness fees that would apply to Deputy Adam Wojciechowski. He was from the Clinton area, and so he had to travel, and we've got the travel expenses and the witness fee there. That would be for $111. It would be for Matt Dean. He was one of our three fishermen from the Clinton.
Sorry. Boomer moment. Yeah, a release of the body. Yes, Breasia's remains were evidence in the trial, so she is not ready to lay to rest yet. With this sentencing, the court proceedings are officially over, and they can release the remains.
Area. And so there would be a total of $100 for witness fees and mileage traveled. For Brendan Rogie, again, one of our fishermen, he would have a witness fee and mileage for $62. For Eric Johnson, again, the third of our three fishermen from Clinton,
This they could have
he
done
would have
at
a total of $90 owed in
another.
witness fees and
But I guess this is
miles
Iowa court
traveled.
proceedings.
And then Jen Peters,
But
who
for
was
me, this
our canine expert,
is
there
not
would be a
necessary.
total of $416 owed for miles traveled because he lives some distance from here. And we're including within that not only the miles traveled when he came for trial, but also for purposes of his deposition testimony and witness fees. So that would be a total of $416. And then finally for Jesse Dow, a total of $62. And again, he was one of the fishermen. Actually, yeah. So he was one of our fishermen, Brendan Rogie. Let me just go back and look. No, Matt Dean, I'm sorry, he was not one of the fishermen. He was one of the individuals that had been incarcerated with Mr. Dinkins. And so that would be
Yeah,
all
they
on
even
behalf of the
brought
state.
in, their case was so weak, they even brought in a prison snitch. Rephrase. They had so little confidence in their case, they brought in a prison snitch.
Than Ms. Langford, who would like to be able to give a witness statement when the time is appropriate, Your Honor.
Thank you. Mr. Freeze, on behalf of the defendant.
Your Honor, on behalf of Mr. Dinkins, we would recommend that any sentence the court imposes here be run concurrently instead of consecutively. Understanding the court has very little, almost no discretion here. Our argument, first of all, is legal in nature. The court in its...
Yeah. Just to make sure here, he has to make this argument. He has no choice but to make this argument as a defense lawyer. This is purely technical.
ruling and its findings of fact, finding Mr. Dinkins guilty under the kidnapping element, found that necessarily Mr. Dinkins had to cause Breasia Terrell's death to satisfy the serious injury element of the kidnapping in the first degree. Under that analysis, we would submit to the court that the kidnapping and the murder would merge into essentially one conviction because it would require the murder of Breasia Terrell to satisfy that third element of kidnapping in the first degree. So the court should only sentence him to a single term of life of imprisonment, even if it is not a legal issue. It certainly is a fact issue. Mr. Dinkins is going to prison for the rest of his life today. He has one life to give. That's all he has to give. Anything more than that is symbolic. That's it. This crime, as the court has set out in its findings of fact, and the court heard for several days, to find Mr. Dinkins guilty, all these facts were contemporaneous as to time, as to date, as to location, as to whatever the motive was. Those are all part and parcel of the same scheme, plan, whatever. We would submit that under that analysis, and that's part of the analysis the court has to consider when it's sentencing someone, that this should be a concurrent sentence instead of a consecutive sentence. This sentence is, like I said, non-discretionary. It's told to us by the legislature that it's one of those crimes or two of those crimes that when they occur, that they check all the boxes that we take away someone's liberty for the rest of their life. This is the worst sentence you can get in Iowa. So we would ask the court to sentence him to 2 life terms, run them concurrent. As far as the restitution, Mr. Dinkins, of course, has to pay restitution. We just received the motion on the crime victim assistance today. Haven't had much of a chance to review that. What I'd suggest is that we hold that open until they file their other request and then give us a period of time to object. If we don't object, that would be entered without further order. And that's all I have to say, Your Honor. Thank you.
Ms. Cunningham, do you wish to address the argument of merger?
Your Honor, I'm comfortable with the suggestion that's been made by counsel relative to the issue of victim restitution.
Thank you. Mr. Dinkins, this is your opportunity to address me and tell me what you would like me to know before I pronounce sentence in this case.
Okay, this sentencing is, for me, a bit unusual. The sentencing I have seen in other trials, we have witness impact statements and stuff like that. Here, not so much. This is very clinical. But here comes Mr. Dinkins, and if you watch my stream with his letter to the judge, I don't know what he's going to say, but just be prepared. You can hear some loony here.
What are you supposed to do when you're told you can't even speak in court, especially when you see and know something ain't right? Logistically, it's like having a gag order, which prevents you from addressing the court with any of the issues. What if your issues are with the judge, the prosecutor?
That's a bit of bullshit. He had every opportunity to speak. He could have taken the stand. He chose not to. But in court, you speak through your lawyers. They know procedure. That's why you have lawyers. He could have chosen to try to fire them if he would. If he could have represented himself. Yeah, in every trial in the United States, as far as I know, if you are the accused, you have the right to take the stand in your own defense. But most of the time, people don't. Oh.
Or the attorney. You are not allowed to put anything on record at any time of these issues during the court proceedings unless it's asked the question of the judge, the prosecutor, or your attorney. What happened to the rights of freedom of speech if a person addressed a matter to the court in the proper proceedings, even if it's in?
And he only feels sorry for himself. Why, I didn't get to speak. You had your chance. You could have taken the stand if you wanted to. You chose not to. And you are speaking now at your sentencing. Proverbial Fly says, just another example of him not taking responsibility and blaming everyone in the room. Yes. His entire life, adult life, that's the person he has been. Never taken responsibility. Always choose crime. Always.
The same spectrum as if your attorney or your prosecutor are addressing the courts or any issues. Your Honor, may I speak to the courts? There are so many various issues people might have at different times of the court proceeding. I believe these issues could be, I believe if these issues could be resolved between client and counsel, then there wouldn't be a problem. But that's not always the case. I'm only going to speak right now because this is my only opportunity to address the court during the closing of this trial, which is kind of too late for me. Even if you do ask your attorney to ask certain questions, sometimes things don't get done. I have a speech that I would like to address the courts with if the judge allowed me the opportunity to say the following. Let me address the facts about everything regarding my case. First, I want to know if I can quote case numbers or just saying the same, either or will be fine to me. Where is the justice in the judicial system, and how do you beat a system that is against you that's not playing fair? When I was in Clinton County Jail, I remember 2 detectives coming to charge me with this case. I remember the female detective saying, we're going to make you look like a monster when this is over. That statement was made during my initial report. Who is they? That's the $1 million question that will arise a little later further in this reading. I'm only going to speak facts. To be honest, I was already found guilty before this case and trial already began. I can see it as racial profiling behind my background.
Racial profiling because of your background. You piece of human garbage. You chose crime from an early age. You have had every opportunity. You got paroled. You got work, whatever. You got paroled again. You chose crime every step of the way. You filth. This has nothing to do with the color of your skin. Absolutely nothing. You're just garbage.
I'm saying this because how everything played out from the beginning all the way up to now. I contemplated over the moves that the state used to hinder my character to fit their benefits. First, they blast my name widespread coverage, negatively nonstop on the news, in the papers, and all over social media, and even on posters. This made me vulnerable towards animosity towards the public and guaranteed people to have a bad image of me in their thoughts. So if I chose a jury trial, this pretty much polluted their thoughts about the type of person they wanted to image me as. And all this went global for their support. Now I'm guaranteed not to get a fair jury selection for trial. And even if I chose a bench trial, it would be.
Here's the thing, you piece of garbage. There are plenty of people out there who know nothing about you. Absolutely nothing, and they couldn't care less about you. These are the people who from time to time serve in a jury. People who doesn't give a flaming fork on who you are. Who didn't read the paper. Who didn't see the poster. Exactly, EU. Dude, you were not famous. There are people, I believe, there are people in the watching me right now, and I've covered this case, who has no idea who you are because they didn't see my earlier streams about this. Yeah.
Sealed with a guilty verdict. So where is the equal liberty and justice in the system when you're being railroaded by the police, the detectives, and others working hand in hand? It really don't take no rocket scientist to see through this magnetic picture. Through these series of events, I know I've been railroaded, so either way, the state had the odds in their favor. The state produced 900 exhibits offered into evidence. I can honestly say I've only seen 35 exhibits before this trial, but I was given 665 exhibits during trial to have for my records. I never had the opportunity to look over 90% of any of this for preparation for trial. But
Evidence were transferred to your lawyers. You do not need to look at every piece of evidence. You can ask for it, but you have no right, absolute right to it. You get the discovery, your lawyers get the evidence, they discuss the evidence with you. Trial strategy is up to the lawyers.
this includes footages as well. So this is what the courts had to offer me. All this was new to me during trial, but I believe the 700 exhibits offered was the shortcut. I believe there are others that the state didn't provide, allowing the defendant preparation for trial by deception by deception. So once again, where is the equal injustice in the judicial system when you're told you can't speak, especially when you see the state ain't playing fair? I do remember being transferred from Davenport to Clinton County Jail behind the bad publicized coverage. I remember a couple of things taking place while I was being there. First, I asked for a change of venue behind the negative news. I also made the comment, man, they're never going to find her because it's been quite some time. As the time progressed, that even made it even slimmer. I also was going to represent myself because all the attorneys that the state was providing wasn't doing nothing in my case. So I just wasn't about to do nothing as well. So I at least was going to try to attempt pro se. When I seen the judge, he made the comment saying, I have no problem opposing this time on you. You need to reconsider your decision because you're facing some real serious charges. When I seen the look in the judge's
Jesus Christ. Every judge says that to a person who tries to argue going pro se. Because, sir, even though you are a career criminal, you don't know law. I almost wish you had gone pro se. That would have been, I mean, geez. you would have forked up so bad. You would have cross-examined your own kid. You would have cross-examined Aisha, your former mother-in-law. At least now, yeah, we know you're garbage. We know you're garbage. But if you had gone pro se, yeah, Jesus Christ.
As I knew then I had to get a jury trial. But through the news press, through the news coverage and the news confirming this I know I had to get a jury trial, but through the news press coverage confirming this verdict with the high profile in this murder case. So my chances of winning even with a jury trial was slim, and if you don't have the right attorney, it's even slimmer. I was told by a birdie that if you have this case heard in any remote area where this is being televised, you would be found guilty, and this was by the state's own officials that uphold the laws. So once again, where's the equal liberty and justice for the system for all? This racism this racism do run deep in the Iowa system for people of color, which I'm not only talking blacks. I know whites also have the same problem as well, but it's more common for the people for men of color. But the profile racism I'm dealing with is behind my background, and almost 75% of their.
Your background is a career criminal, a child rapist. That's your background.
News coverage, they mention my background or something in regards of that nature. If I didn't have that, I would have never got charged. When I was in Marshall County, before this trial began, here they go again, sliding negative news coverage of my background a week or so before my jury selection was about to begin. I said something to my attorney, which all he said was, there's nothing we can do about that. I made my mind up that if they're not going to play fair and I can't get a fair jury selection, I should just take my case back to Davenport. Once I was transferred to Cedar Rapids County Jail, before my trial, the day of my trial, here they was again mentioning my name on the news again. I really don't know a lot about the laws, but I know enough when I see a lot of my constitutional rights being violated from the beginning up to now. Through this racial profile, the state and others have shown ambiguous behaviors that sought constantly through these drawn lines. But what can you do when you're told you're not allowed to speak? I can only play with what's provided by the courts and the state's rules. Me and my family tried to contact my attorney on several different occasions, which I was told that he was working on the other client's case. To you, Judge Latham, you handpicked my attorney. I went through 3 different attorneys, but the handpicked one was my last option. I'm not going to bash my counsel because I know he personally did more than the Davenport public pretenders. But I know he overlooked some things in my case. I'm not quite understanding how I wasn't given 665 exhibits or seen any footages before this trial. He did make me believe he was going to raise these issues, but I never seen nothing come forward. I've asked several times, but was told you have nothing to worry about. I was being bamboozled by the blind side while nothing was being introduced or brought to the surface. I really don't know if this would have made a difference because the judge was just looking for any reason to get this verdict. I can truly say after hearing the judge's remark and while I was in Clinton and in Cedar Rapids, the judge's demeanor spoke real clear to me of the courts, which made me realize that I never had a chance to win from the beginning. So once again, where is the justice in the judicial system when you see the judge in his own personal emotion, then you hear the judge say that everything.
If it's not objected to in trial, there's nothing to appeal about. But I do know that the defense has more than a few standing objections to stuff that was said and brought forward in this case. So if he can get himself an appellate lawyer, well, there are some issues. Will it rise to the level needed for a new trial? I don't think so. His lawyers did a damn good job, but it wasn't enough because in all of this, which I still say, the prosecution's case was a cluster F, but in there was enough evidence to find a conviction.
You made everything made against you, he find credible, then tell you everything you said is a lie and untruthful, even when they know you know they lied. I do understand the power of the pen, especially when the power of authority is being abused behind watchful seers. I do wish situations were different, but the state has played dirty when they know they didn't have anything on me while I was their easiest target behind my background. I would have to say this is overwhelming, but I have to stay focused and grounded. I have more hurdles that I have to jump through, but I have to take things one step at a time. For those who believe this fight is over, guess what? Through my resilience, you will see me at the next checkpoint, God willing. My main focus is getting back home, but where is home after all this? Where is home? But right now, I have to stay focused on what's more important. I'm only able to play with what's provided by help from those who are watchful seers as well. I know the court has played unfair towards me. I played this scenario numerous times in my head trying to figure this out, but I keep coming up with the same answer. You never had a chance from the beginning. So I say this to you, Judge Layden. What if you wouldn't have never found me guilty and found me innocent? What would have been the outcome from their perspective? Everybody have to report to somebody, but God is the final ultimate judge. I do forgive those who made past judgments against me unknowingly. Never once have the courts asked me about anything of the clothing or the shoes or during any of these allegations. I honestly believe that these items are not important, but it was just giving the state more ammunition to point a finger negativity towards me. Just like me not opening Andrea's door with my key to allow the police to walk into her residence. I don't have them rights for that. I don't pay no bills at her apartment to allow anyone access to her place. I didn't give no approval for her place for that. I didn't give no approval for a place that's not my place of authority to do. On the footage, I told him I checked and he said, let's check. And then lied and said, I told Andrea, and then he lied and said, I said it was okay for him to go into Andrea's house.
No, he didn't. He knocked on the door. Andrea opened. He asked, "Can I search the premises?" In other more words than that. She looked at Henry and said, Did he allow that?" And Henry said, "Yeah."
But I will have to say the video do speak for itself. I will have to say there was one person's statement that was consistent from the initial report to deposition to trial, and that was Miss Gardner, Aisha's mom. I do recall her talking to Aisha before I left with the kids, or I wouldn't have never left with either kid. I'm still stumped about 900 exhibits plus, and I'm saying plus because I've only received 700 and the state knows that the ones that would have set me free, they used deception and sabotagement, but made a mistake by giving me 665 exhibits during trial to go through and to cipher through after trial. I know I was given 665 because I counted them, which I've already had 35 before this trial, and which gives me 700 in total, except for the ones I gave my attorney when the state moved them exhibits to move things into mobile to fit their exhibits. I need that letter back, Chad, if you don't mind, the one that I gave you.
Yeah, I covered the letter in a previous stream, and that is just Mr. Dinkins not knowing what is procedure and what is not. He turned over a letter to the judge before he was convicted, already going for some kind of appellate issues that he asked for. I don't. Yeah, it was bad.
Pertaining to Aisha. If I had 120 footage of video with 80% showing nothing, I can make a story up about any vehicle or make anything appear where I want it to be, especially if I'm able to take what I want to produce and the rest of it produce the rest where, let's see, oh, my bad. Especially if I don't want to.
Yeah. Too bad
Okay,
your
and not
phone
produce
was
the rest where
up
nothing else
on a
is
few
being presented,
occasions.
but what I
So,
want the world to see.
to confirm you
I
actually
know
were
that
at
they
some of these
didn't give
positions.
my attorney that information as well. I'm the one who said that I went to the quick shop, which was used against me. I'm the one who said that me and my son stopped by the mobile, which was used against me. If I would have got on the stand, you would have probably found a reason to use that against me as well. The only reason why you didn't use my son's statements saying he seen me kill his sister, it would have made every lie truthful. It would have made everybody lies untruthful, which you couldn't have that. So I say once again, where is the justice and equal liberty in the system? Why wasn't Andrea's initial statement video played? They played mine, they played Aisha's, they played DL's, and they played Jared's. I know the state, I know and the state know that Andrea's initial video recording says something totally different. That's why they didn't show them contents or produce that video, which I'm not quite understanding why my counsel didn't bring that forward as well. I'm not even.
Because it was no use. Because there was evidence and testimony about her being extremely submissive to Miss Dinkins. Once she was out from his control, then she started to sing. And what she told wasn't even that damning. Her only testimony was what happened that night when she woke up, when she looked out the window. That's more or less it. The facts were against you, not Andrea. The facts was against you. Now, could the defense have played the first interview? Yeah, but for no use. It's easy to refute. Easy. So it's of no use. I would assume that the defense knew that even with that, it would have been even more damning for you.
I'm not even sure if he even had that information because I never seen any footages but what the public saw during trial. I can speak for days about what happened, but since my attorney didn't bring up any issues on motions, what are my chances now? Even Jared's statement are twisted up. But like I said, anything the court can use to find his verdict guilty. There it is right there in the eyes of.
You chose a bench trial. That made the judge the finder of facts. A finder of facts can evaluate each piece individually or in combination, just as a jury. and the facts were against you. Now, the prosecution's presentation of those facts were horrible, but yeah,
The public racial profiling. When I was given them exhibits, I wrote the court during this trial saying with urgent attention, quoting case documents, law from the Iowa Law Book of Iowa Rules of Criminal Procedure, stating the following item and its reasons, but once again, it was overlooked by saying, I'm going to give both parties that information. You have to talk with your attorney. I know I'm not allowed to put case numbers, but I sent the statement of the following items of evidence in possession or control or are necessary for preparation for the defendant to inspect copies, photos, or exhibits that the state intend to offer into evidence at trial or belonging to the defendant. From the law book, I sent consequences of failure to make disclosure of discovery, failure to disclose supplements or of early responders to admit, failure to disclose or supplement. If a party fails to provide information or identify a witness as required by Rule 1.5, the party is not allowed to use that information or witness to supply evidence on a motion or at a hearing or at a trial, unless the failure was substantially justified or harmless. It also says, if in disclosure of expert testimony, if a party must disclose to the other party of any witness, it is also, expert testimony, a party must disclose to the other party identity of any witness the party may use at trial to present evidence under rules of evidence, saying any exhibits that will be used to summarize or support the opinion. Are also sent grounds for vacating or modifying judgment and material evidence newly discovered which could not be reasonably diligently have been discovered and produced at trial with official comments and Act 1943 federal practice. I'm only able to do what I can just to be rejected or overlooked once again by everybody. When you ask your counsel when will certain things be brought up and he tells you through other witness, but it's misleading of your counsel when he knows that the state is going to rest and there is no more witness to raise the issue, but he tells you different. But you are now allowed to speak during trial. My dearest son, you know I love you with all my heart. I know everybody just
oh, Jesus Christ, what is he going, oh. Now, if you follow this trial with me, you know how I felt about the kid's testimony. I think the prosecution almost threw away the case by using the kid as a star witness. They should have used him as a collaborating witness for the things they could otherwise prove. That was horrific to see. But yeah, let's just go through this.
distorted your thoughts where you're trying to figure things out in your own head. I'm sorry that you had to deal with all this abuse from those who made you lie about all these stories. I know you remember me, you and Bree counting money on the mattress up to $2,000. I was so proud of you because you was a fast learner. I know you are mad because you believe I lost your sister, but guess what? Your dad ain't mad at you behind the lies. I love you more than the lies. I know one day you will tell the truth, but even if you don't, I'll still love you regardless. Ms. Culberson, I also respect your initial report and your deposition, but somewhere along this course, your whole story changed like 360. I'm not sure what took place or what type of situation you might be in, but something made you spiral from out of the normal. You know I never been violent towards you or showed any aggression. I've only been protective of you. That's why I was kind of surprised by the statements you made, which kind of had me thrown off the loop. Just please give my things to my family, and I'll leave it at that. Aisha, you said something in your deposition that caught my attention. You said you wrote me 15 letters from the beginning of this case. Well, it's sad to say, but I believe I might have only got 2 letters that slipped through the cracks that they didn't catch. They took them letters before I even had a chance to receive them. That was their intentions, to have you turn against me. That way it makes it easy for them to point a finger. I even gave this letter to my attorney. But the only time that I was able to contact you, and that's when I was in Clinton. I text you. I know you remember because you kept asking me, who is this? I never said who I was. I even text your mom number as well. I will have to say your initial and depositions are totally different from your trials, straight the opposite, which I know them people played a factor as well in that. So just for the records of the court.
Yes, Nanya, she was the first to point the finger towards him. She said, when the first cop showed up at the scene, she said, "How could you lose my baby?" At that time, she only thought that Breasia was missing, wandered off, but she still pointed the finger at Mr. Dinkins.
I wasn't in any shape prepared in addition for this trial. My resilience will continue to keep me focused and peaceful during these hard moments. I do have determination that through these challenges, I believe in the very definition of faith. My faith ignites hope in my heart to
You don't have
overcome
faith.
these trials and tribulations. Right now, I'm the
You're
underdog rising through these misfortunes.
You're a child rapist, career criminal who blames everything on everybody else but you. Now you're claiming racial profiling? No, you're a criminal with a history of raping children.
I have to stay strong through this predicament. My God taught me failure isn't final. Your fight is only over when you throw in the towel. What initiate champions? The Almighty. My endurance is built strong like never before. My joy is beyond any experience I ever imagined. I will overcome this. I am encouraged that a power far beyond my physical ability will appear and give me spiritual armor through this fight of lies with truth that will set me free.
Ms. Cunningham, I see that Ms. Langford has left the courtroom. Would you like to address the court?
Your Honor, let me see. I think she's probably, is she coming back? She's coming back.
Yeah, I would also leave the courtroom when he was speaking.
Ms. Langford, are you ready to make your statement?
This is
Ms.
Breasia's
Cunningham,
mother.
I would ask that you take the witness stands. I think that would be easier, please. There you go.
This can get emotional, so just so you all know.
Ms. Langford, you may proceed if you would just please state your name and spell your name for my court report.
Okay, my name is Aisha, spelled Aishia, Langford, Lankford.
You may proceed.
All right. Your Honor, my name is Aisha Langford, as I said before, mother of Breasia Terrell. Before I continued, I'd like to thank the court for providing me the opportunity for me to speak today. July 9th, 2020, exactly 3 years ago, since the last time I saw my baby girl. When I dropped her clothes off for her in DL after I got off work and showered and headed over to the Jersey Ridge Apartments complex. Once I got outside the complex, Breasia running out smiling as she always does, a smile that can light up a room, any room. We spoke for a few minutes while she held her dog, Chloe. She said she loved me, and I watched her run around to the apartment complex while her lovely locks bounced away around 6:30-ish. Those are my last words with my baby girl. So I wrapped my mental around her face. Her last words, she said to me, the amount of pain I felt and feel that no mom should ever have to feel, because man, that stuff hurts real bad in a different spot. I didn't even know it existed until you, Henry Dinkins, changed that for me. Broke my trust and emotions I had the day you took my baby girl from me and just gunned her down like she was nothing and left her and never said a word at all. It's really painful that a statement could bring so much anger. I have a number of questions for you, Henry Dinkins, surrounding that night that played through my mind every day. Did she want me? Was she scared? Did she see those gunshots coming? Did you shoot her while she was trying to get away? Did she scream for help? Did she beg you to stop? Did you see in her face when she realized she was shot the first time? What was her last words? Did you stay and watch my baby die? How long did she suffer? Did you watch the life leave from her beautiful hazel eyes? What did you do to my son? Why? Do you know the answers to any of these questions I asked, huh? Henry Dinkins, why you sit in this courtroom as if this shit don't hurt you? Watching you during these proceedings. That isn't right. You sit there with smiles and chatter during sensitive things and then try to speak to me when you never once spoke to me after July 14th, 2020. You remember. When I saw you in Scott County Jail telling me you didn't do this, but why you haven't said nothing then? Why? Henry Dinkins, closure doesn't exist here in this case. Justice doesn't exist here in this case. You didn't just take away my baby's life. You didn't just take away my baby's life. You took away everything from me. My family's sense of security, laughs, health, and potential. Potential for Breasia to be someone's wife. The potential to be a mother, a college graduate, prom, everything. Oh, my baby girl, Henry. I went from believing I wasn't the best mom, but made things happen, but best I could, to downing myself day in and day out as, what kind of person am I not to have protected my daughter? I've broken myself down many a times over and over, analyzing text messages, calls, and conversations about everything, trying to figure out what I could have done differently. I watched my oldest son completely lose his childhood and be the cast of being the man of the house for me, because I was truly broken the day I got the call stating they found my daughter. I'll never forget. March 22nd, 2021, around 7:30 p.m. They told me they had information I have been waiting on. So that night, my tummy was in knots, and all I did was cry, and I held my pillow so tight, trying to hurry the nightfall so I could get up, so I could rush the kids to school and get on that highway near DeWitt, March 23rd, 2021. Once I got out there, it was a feeling I can't even describe, because it was the snuggle on my heart. Mentally, I was going insane because that was a different feeling in my body I wasn't used to. I kept myself covered from the media footage that was other, while I shed so many tears inside because I couldn't describe that my daughter laid behind those squad cars and big RV man. I couldn't do nothing to save her. All I got a glimpse of. All I got was a glimpse of a damn blue bag, man, that crushed my whole soul. I promise, broke me down, and still am. And my son commits to every hurt need I need, and still does. I watched my youngest baby become unrecognizable. At times, with the amount of anger he sits and holds to, from this trauma you put him through. He's so hurt, he has no idea how to even understand or even cope with the loss of his best friend, partner in crime, his sister, who helped him through so much of his life. He would to overcome this and gain himself back and be somebody. He will not be what you have put him through or even made him sit through. We are suffering from so much with anxiety and depression at the top of our list. I can't work at times because all the trauma on top of the world of things I encounter at most jobs, the social media crap pushed me into a shell I haven't been able to shake quite yet. Our lives changed. 3 years went past us with no stops, right before our eyes. And here we are in this courtroom seeking the justice she deserved, so she could be laid to rest properly. Still yet, this all feel like a movie. I haven't changed the channel to because this can't just be it. Like, that's all. That's the piece that sinks in, still hurt, because I thought hearing you get a life sentence with no possibility of parole will help me sleep at night. And it just doesn't, because she didn't have to be gunned down like that, nor left like that out there like she was just trash. She didn't deserve that. She didn't deserve to have her lifeless remains shown across the TVs. Like she did. She did it, Henry Dinkins. So whatever you get won't be enough, because your family get to come to see you. And my baby is just that, just gone. And never, ever, ever coming back, as she left me July 9th, 2020. Peace, understanding, and forgiveness will never come. I also truly hope what you did to her will haunt you for the rest of your life. I'll hold on to those good memories we shared, and not how you left her and how she laid across that damn creepy swamp place thing where you left her and said not one word. How could you? How could you be such a monster, Henry? I am thankful for the justice for Breasia Terrell and my baby boy.
Thank you. Before I proceed with my judgment and sentence in this case, I must address some of the statements made by the defendant in this case to the court. This court has provided the defendant with very competent representation during the entire course of this action. Actually, the attorneys representing the defendant in this proceeding and in this trial, his last counsel, are very competent. We're very zealous in the representation of the defendant. Couldn't have asked for better attorneys.
I must agree. They fought tooth and nail for every piece of evidence, every testimony. They fought for him, as they should. And there he is, sitting and thinks he knows better. But let's continue. We're almost done here.
The court made its decision based on all the evidence that was presented in this case. The court's ruling was based on facts. I find no legal basis to grant any of the defendant's motions for judgment of acquittal or new trial if that was the intent of some of his statements as a pro se motion. Because the defendant was found guilty of 2 Class A felonies, this court has no discretion on what the sentence shall be imposed. Rather, life imprisonment is mandatory. The court notes, however, that the defendant has an adult criminal record dating back to 1989. This history, coupled with the horrific nature of these offenses against his own child sister, requires that this defendant be removed from society for the protection of society. This sentence provides for both punishment and for protection of the community. Mr. Dinkins, it's unconscionable that you would take such actions to murder.
Eric Olsen says, that is such a big problem here. Too many times criminals get a slap on the wrist, a light sentence, and then let out again to repeat or commit worse crimes over and over. Yeah. I can, before this trial, just by listening to the prosecution, he had been sentenced to a combined 25 years in prison before this. He served less than 2 years of those. Always let out. Well, you had him raping a child. That he forked up. So he went to prison for a long time. But after that, hardly anything. He should have been put behind bars for a very long time, much sooner.
A 10-year-old child who was entrusted to your care. It is very clear to this court that you have no conscience or remorse for your actions. You blatantly lied about trying to find Breasia. You took no legitimate actions to find her. You knew exactly where she was. Due to your extensive criminal history and the fact that you removed Breasia from the place that you were authorized to care for her, and then take Breasia to a dark, deserted area in the country and shoot her in such a horrific manner, supports the finding that the sentences to be imposed on both counts 1 and 2 shall be served consecutively. Mr. Dinkins, pursuant to this court's finding you guilty on September 15th of 2023 of murder in the first degree in violation of Iowa Code Section 707.1, paren 1, paren A, and as provided by Sections 902.1, it is the judgment and sentence of this court that you be committed to the custody of the Iowa Department of Corrections for the rest of your natural life without the possibility of parole. Pursuant to this court's finding you guilty on September 15th, 2023 of kidnapping in the first degree in violation of Iowa Code Section 710.2, and as provided by Iowa Code Section 902.1, it is the judgment and sentence of this court that you be committed to the custody of the Iowa Department of Corrections for the rest of your natural life without the possibility of parole. DNA sampling will be required. Each of these counts will be served consecutive to one another for the reasons stated earlier. The Iowa Medical and Classification Center is designated as a reception center to which you shall be delivered by the sheriff. Pursuant to Iowa Code Section 910.3B1 in paren 1, you are ordered to pay to the heirs of Breasia Terrell, and as noted by the county attorney, to Aisha Langford, $150,000. Mr. Freeze, do you wish to address Category B expenses at this time?
We're going to leave that given Mr. Dinkins' status presently and going forward, he'll certainly be indigent, qualified for waiver of category B expenses.
Ms. Cunningham, do you wish to address the court on this matter?
No, Your Honor, and the state would not resist the court entering that finding.
Based on that, the court will find that Mr. Dinkins is indigent and does not have the reasonable ability to pay Category B expenses. Now that you have been sentenced, it is my duty to advise you of your right to appeal. Under Iowa law, you have the right to appeal your conviction and sentence to the Iowa Supreme Court. In order to do so, you must file a written notice of appeal with the clerk of this court within 30 days from today's date. Failure to file such notice of appeal in that fashion will be deemed a waiver of your right to appeal. In other words, you will lose it. If you think you want to appeal but don't think you can afford an attorney or transcript of these proceedings for that purpose, you have a right to make application with this court for court-appointed counsel and a transcript of these proceedings, all at the expense of the state of Iowa. Just be aware all of this must be done within the 30-day time limit that I have just outlined. I'm sure if you have any questions concerning this, Mr. Freeze or Mr. Waters would be happy to address this with you. I'll acknowledge receipt of any pre-sentence investigation reports that have been printed for the purpose of today's sentencing. No appeal bond will be issued in this case. Minimus will issue immediately. Anything further in this matter?
Your Honor, I do want to make a record relative to some comments of Mr. Dinkins. Mr. Dinkins spoke to the issue of the state having provided all of these exhibits during the trial that he had not received. The state did comply with all discovery requests that were made. I would note that there were a significant amount of photographs. There were a significant amount of body-worn camera footage that was generated by virtue of officers and their involvement in the investigation, as well as recorded interviews. There is a record that would reflect what was provided by discovery, but I want to speak to the practice of this particular prosecutor when I am in trial. My practice has always been one to make copies of any exhibits that I'm going to introduce during the trial and provide that to counsel. So while they may have received that during the course of discovery, I find that it's very beneficial for defense counsel just to have a copy that I'm presenting to the witness right there on the table before them so that they can follow along as I'm introducing those exhibits. I want to make it clear that when Mr. Dinkins suggests that these were exhibits that were just came out of the blue and were presented for the first time, that was not the case. It's simply the state's way of being very considerate of my colleagues on the opposite side of the table and making their jobs easier and making the process flow much, I think, more efficiently by providing those copies. So I think it's important to make that record. Additionally, Mr. Dinkins had indicated that there was a lack of notice of various witnesses. Certainly the court understands and defense counsel understands that with respect to any type of criminal prosecution, the state's required to file minutes of testimony. And then if there are, supplemental additional minutes of testimony that need to be filed, that is done. There were several sets of minutes of testimony that were filed. Every witness that was called to the stand to testify were individuals who were listed in those minutes of testimony. And every report that documented their statements to law enforcement or any investigative steps taken by law enforcement was a part of those investigative reports. And in fact, the state would further speak to the issue of expert testimony, particularly that of the FBI's testimony. My predecessor, who had been on the case before I took office, had filed additional minutes of testimony indicating there had been a USB drive provided that set forth all of their investigative reports. Even though that discovery had been provided, I went through the process of filing duplicative additional minutes of testimony to specifically identify every one of those individuals and to provide each of their reports that were generated through the FBI laboratory. And I would also note that when Mr. Dinkins speaks to the change in testimony, every witness who got on the stand to testify, the testimony that they provided stemmed from statements that was made to law enforcement. And there was no steps taken by the state to coerce any of these witnesses to provide fabricated testimony. Certainly the state understands its obligation, but even if we, didn't have, a strong sense of obligation to that, the state, our job first and foremost is to do justice, and justice takes on many different faces. And there are times when justice is best served if the facts are such that they indicate there should not be a prosecution. But in other instances, justice is served when crimes have been committed and the state goes forward and engages in those prosecutions. The state is very mindful of that obligation, and there was nothing untoward in any of the actions taken by the state. And that's the only record that I wanted to make for this, recognizing that there will be additional proceedings, I'm sure, relative to the appeal or any future post-conviction relief action.
I will leave the issue of the amounts totally payable to the Crime Victims Compensation Assistance Program. I will leave that open for further hearing. Thank you.
Thank you, Your Honor.
Anything further, Mr. Breezy? No, thank you. I'll conclude this matter.
And off he goes. And he will never see the outside of a prison again. All right. This will conclude my coverage of this trial, of this case, but Breasia, you never got to grow up. You were robbed of that opportunity. As far as justice, this is as good as it can get, sadly. Rest in peace. All right. Yeah, thank you all for being here with me. Thank you for trusting me to guide you through this. And, well, what's next on my docket? Well, Friday, we have something a bit more fun. It is finally Friday, and I am celebrating 3,000 subscribers. Yay! And there might be a members-only stream attached to that, because we need to talk about Hugo. And if you've been around long enough, you know exactly what I mean. All right, I'll send you off to Dave so you can watch some when the government forks up everything. Thank you for showing up, everybody. I'll see you all later. Have a nice day, and talk to you later. Bye-bye.